number 192 in the matter of Henry versus Fischer. Thank you. Counsel, good afternoon.
Good afternoon. May I please reserve 2 minutes for rebuttal?
2 minutes? You may.
May it please the court, my name is Donna Lee of Counsel to Main Street Legal Services. Together with co-counsel Cleary, Gottlieb, Steen, and Hamilton, we represent Mr. Javon Henry, the petitioner. What is at stake in this case is the process due to a prisoner before he can be placed in solitary confinement for a period of years. We ask this court to reverse the decision below and hold that Mr. Henry preserved the right to judicial review when he requested documents and witnesses during his hearing, and the hearing officer denied those requests.
Let me ask you just a little piece of that. One of the issues I think raised is whether he was entitled to a redacted version of certain documents that may have had confidential information or had information that didn't pertain to him. Did he have to preserve that request specifically if he's accepting the fact that he's not entitled to the entire document or may not be? Does he have to go, at least with respect to that, one step further and say, you know, I request that I receive a redacted?
No, Your Honor. When
Why
Mr.
not? How would the hearing officer know that that's what he was looking for?
Although the reasons for the specific request may be something that would be considered on a merits review of the claim, once Mr. Henry asked for the incident report, the logbook, and the to-from memos, and once the hearing officer denied those requests, that issue is preserved for appeal. The standard that applies under the CPLR is that the request of the document, once denied, preserves the issue for appeal. CPLR 5501A3 provides...
So that means that it's the hearing officer's obligation to say, no, I'm not going to give you that document, but I'll redact it for you and give it to you that way.
Your Honor, on the facts in this case, the documents were denied, period. If the hearing officer had offered to provide redacted versions of the documents, then that might create a new legal issue that Mr. Henry would then have to object to. But in this case, where he asked for documents that were denied to him, that should be sufficient to preserve the issue.
To preserve any argument with regard to those documents?
Yes, Your Honor.
What
Yes.
about the witness refusal? I just want to ask you about that for a moment. The regulation says that the hearing officer has to state the reason for a denial of a witness. And here, one of the witnesses wasn't denied, he refused to testify. Where does it say that there's an obligation for the hearing officer to treat that in the same way that a denial would be treated?
Your Honor, the facts with respect to inmate Kaufman and inmate Burton fall squarely within this court's precedent in the Barnes case, where the hearing officer told Mr. Henry that that inmate Kaufman refused to testify, but gave no reasons whatsoever. There's no inmate refusal form in the record. All that's in the record is the assistant form, and all that there is a check under the no, witness refused to or declined to testify. So in that instance, it's that issue ought to be ruled on as a matter of law and requires reversal. The state should not be permitted to insulate its prison disciplinary proceedings from judicial review by imposing a technical and complicated rule of preservation that's higher than the rule that applies to counsel in court cases. a prisoner has a constitutional due process right to call witnesses and present documentary evidence under Wolf versus McDonald. Mr. Henry cannot be deemed to have waived that right and to have voluntarily, knowingly, and intelligently waived that right. What we're asking this court to do is to clarify that in the factual context presented here, an affirmative request that is denied does not require an additional objection or exception. Respondents, in fact, have conceded this point on page 11 of their brief. They state that they're not arguing that to preserve an Article 78 challenge to a hearing officer's ruling denying a requested document or witness, the inmate lawyers must state a formal exception to the ruling denying his request. And on that basis alone, the decision of the Appellate Division and the Supreme Court ought to be reversed. As this court knows, the population of individuals who are at risk in prison disciplinary hearings vary in terms of their levels of education, ability to speak English. There's high incidence of mental illness, of intellectual disabilities, of a variety of problems.
Counsel, on this record, Mr. Henry repeatedly asked for witnesses and documents. Would you say that that would be different if he only asked once and then didn't get it, and that would be it? Would he
No.
still have preserved his issues? You're suggesting that because he repeatedly asked here and then did not make any exception or objection when the hearing officer said you can't have that, or the witness refused to testify and he said okay, or, you know, when he didn't get the documents, he said, well, I guess I'm wasting time here because I don't have the proper documentation. So that was enough to preserve, even if he hadn't repeatedly asked for these things.
Yes, Your Honor. We ask this court to make clear that once a pro se prisoner in a prison disciplinary hearing where he is at risk of years in solitary confinement makes even one request that is then denied by the hearing officer, that issue ought to be preserved for judicial review. In this instance, it's even more clear, based on Mr. Henry's repeated requests for documents and for witnesses, and his assertion at the hearing that he objected to the whole hearing after the hearing officer had denied those requests. In his administrative appeal that he filed pro se, as well as Prisoners' Legal Services administrative appeal, he again raised these issues for review.
Let's stop with he objected to the whole hearing. If that's all he had said here, as opposed to I want specific witnesses or I want specific documents, would you say that he had preserved those objections?
If the hearing officer did not have notice and an opportunity to address the concerns, then we would be in a different situation. But here he requested specific, he wanted Officer Faulkner, inmate Kaufman, inmate Burton. He wanted the to-from report, the logbook, the unusual incident report. Once the hearing officer denied all of those requests, he preserved those issues for review.
How would under your rule, how would an inmate communicate that he or she is no longer interested in what they've requested? Do they have to then say expressly, I have now changed my mind, I'm abandoning that request? Do they have to say that explicitly?
Your Honor, yes, that is the standard that would apply when a constitutional right is at issue. What is required is a knowing, voluntary, intelligent waiver, and there has to be evidence
I guess
of that.
my concern is, if your point is it's very difficult for this particular population to be able to do more than, say, as he has done here, I object, I want these things, repeatedly making that comment, how is it that they would be in the same position to make what sounds to me like a very well-formulated expression of abandonment of the request?
Your Honor,
How would they know enough to do that? So otherwise, it begins to sound like an automatic rule. You request it, if you don't get it, you've now got an automatic appeal.
in that circumstance, Your Honor, it would be incumbent on the hearing officer to expressly ask and have a kind of colloquy with the inmate to see whether or not he was waiving the request clearly, knowingly, intelligently, voluntarily, or whether he wanted to continue to press his case.
So
for
the hearing
having-
officer will have to ask, do you still want to hear from this witness now that I've told you the witness refuses to testify?
Your Honor, without saying that that would be sufficient, that would be necessary in order to try to make that clear a case.
Thank you, counsel. Counsel?
May it please the court, my name is Marcus Mastracco, I represent respondent here. We have a very narrow position here, basically saying that the hearing officer needs to be put on notice of any of the procedural issues that need to be addressed.
How can they not be on notice when he's repeatedly asking for these very specific things?
What's being lost here, I think, is why does he want it? In other words, so he wants the corrections officer, and they talk about why do you want him? And he wants to ask him the exact same questions. He wants him to duplicate exactly what was said before.
But that doesn't mean, even if it's completely without merit, even if the hearing officer had every right to deny this witness, that doesn't mean that the argument is unpreserved
But
or
that's-
waived, and I'm not sure what you're talking about now.
I would say
or-
waiver to me, I think these terms get kicked around quite loosely. Waiver to me is the waiver of a right. In other words, you have the right to attend a hearing. If you waive that, that's got to be knowing and voluntary, and there's a whole different slew. Once you're at the hearing, if you want to preserve a specific issue for review on administrative appeal, which is different than a trial here, these are very, CPLR doesn't apply, SAPA doesn't apply, this
No,
is
but
all regulatory.
Isn't your proposed standard more onerous than we place on lawyers in either civil or criminal proceedings when it comes to
Well,
preservation?
first with trials and the civil type things, a lot of this has been handled beforehand. In other words, it's very formal. You have pretrial, you have discovery, you have pretrial hearings, you have pretrial.
No,
But we're not.
Somebody's testifying,
Your Honor.
objection, Your Honor, overruled. That's it. You don't have to say anything more.
But we're not saying that he has to say, I object on a very formal ground. But what we're saying is if he gives a specific reason for wanting something, or if the hearing officer rules on a very specific reason on denying it, if he has a problem, it's very simple. In other words, he had to say with the CO, all he had to say was, well, I'd also like to ask him, what would you like to ask him? That's very different than simply saying, well, I want to ask him everything, and I want him to testify to everything.
Yeah, but I'm a little unclear, because it seems to me from your brief now, you've abandoned the position that you took below in the Supreme Court and at the appellate division, that he hadn't preserved anything, and I'm not clear
I don't
what
think he's
your
preserved
argument-
anything. I don't think he has preserved much of
You're
anything
saying
that he's
now-
arguing.
I thought your argument before this court now is that he didn't give the right, he's asking for different reasons, and I don't understand what those different reasons are. I don't think Mr. Henry has changed his position at all throughout the whole process.
I think the unusual incident report is another example, and I think there, he's told, he doesn't really say why he wants it, and when he's told that he's not mentioned in that, he's smart. He uses it as a sword. He says, yeah, that proves I'm not involved in this incident. I'm not even mentioned in it. He can't now turn around, as he did in his petition, and say, oh, by the way, it also might list some other inmates who were involved in this that I would have liked to have called as a witness. If he raises it on administrative appeal, then they're going to have to reverse that. And there's over 60,000 of these last year, Tier 2s and Tier 3s at
But isn't
different
his
levels.
statement just a reaction to what the hearing officer is saying, as opposed to abandoning some other statement he might make about his interest in that document and how that document might help his position at the hearing?
But if he wants to raise that issue, all he had to do was say that. In other words, we're not holding him to a formal kind of feet to the fire here, where you have to say, oh, I'd also, but it's just a reasonableness. And I think the appellate division gets this. I think there's a balance here. They read these, they say, I wouldn't,
So
if he's getting pushed
got
around.
7 reasons, he's got to say every single one of those reasons after the hearing officer has said, I deny the request. He's got to then say, okay, here are my 7 reasons.
No, well, if it's, he would at least have to say, he's got to alert him as to what he would want it for, other than what's just been denied, yes, in a sense. And it's kind of curious here,
He says
because.
it's going to help show I'm not there.
But he's
I didn't
already.
participate in this conduct.
Right, but that's already been agreed to by the hearing officer. In other words, the hearing officer says, yeah, I'll agree to that. You don't need it. I'm agreeing. You're not in it. And that's fine. But he's not making that argument. He makes the argument in his petition that, oh, I had other information I needed, such as witnesses. But what's interesting is 8 inmate witnesses were listed in the misbehavior report, including victims, and he doesn't call any of them. That's why this hearing's very short. That's kind of odd.
That struck me, and maybe I'm just misreading the thing, that ought to be reviewed on appeal.
What's that?
Well, you're saying, well, he did this and then he did that, but early you said it's not preserved. You know, we shouldn't even bother with this because it was not preserved.
Correct.
And as has been pointed out, now you're saying it is preserved, but with certain issues.
Well, I'm saying you preserve issues
are
is the way we present it. He hasn't preserved what he's trying to argue
Now.
here. Correct. Or what he argued in court.
Was it, I just don't remember, was it reviewed that he asked for the incident report and it was denied? And somebody said that was right or that was wrong?
Not that I'm aware of, no.
Because you argued that it was not preserved.
Right, which is also a peculiarity of this case, to be honest with you. These aren't usually handled in motions to dismiss, to be honest with you, on a preservation-type issue. It's just an odd circumstance. Also, because normally you're going to challenge this on an evidentiary reason in a petition, simply because you have so much confidential information. That's just a matter of course, but it wasn't done here.
Well, what do you say, counsel, to inmate Kaufman, who said, or at least the hearing officer said, he was refusing to testify?
I'm going to
until
sound like a broken
inquires to
record,
why.
that it's an oddity upon an oddity here to me, in the sense that I think a fair reading of this transcript is that the hearing officer thinks he doesn't want him anymore. I think he feels he's abandoning him. And I say that for a few reasons. He reminds him, he asks for him several times throughout the hearing, either by location or name. And then the hearing officer finally says, well, he looks, as best we can tell from just the check mark on the assistance form, and says, well, you know he's refused. And the inmate doesn't seem to, he just says he refused, yes. Once he's reminded of that, it's almost like I think the hearing officer hears, I don't want him anymore.
But you know, counsel, I've read a lot of these transcripts, and in some of them, the inmate will repeatedly object or disagree, and then the hearing officer seems to think that the inmate is getting agitated, and sometimes even excludes them from the hearing room. So doesn't this, I'm concerned that this really places the inmates in a very difficult position. They're in a place where respect for authority is paramount, and if they start questioning the hearing officer too much, they're gonna get the wrath of the hearing officer.
And that is correct, Your Honor. I think that's why I think this is and I hate case by case, but I think there is an equitable balance here where you look at how was this handled. If the inmate had said, I'd like this witness, and the hearing officer said, denied, move on, I wouldn't expect the inmate to say a word about that witness, and everything would be preserved no matter why he wanted them, because the hearing officer didn't address
But
it.
the other question is whether the hearing officer has the obligation, should know that when an inmate refuses to testify, that they have an obligation to find out why, if no reason is given.
I think on this particular, again, I'm looking at it, and what I'm looking at is, and I hate to say this if you bear with me 1 second, but basically, the reason I think the hearing officer hears he's being withdrawn is, if you take a look at what's called the 2176, we throw these forms around, but at the end, he's given a written document which shows who was called, who testified, who didn't, everything. This inmate isn't listed. There's also a hearing record sheet, same idea. They're written, and he's not listed, and it's not listed as refused or anything. It's almost as if he isn't called, and it's a peculiarity of this
Do
case.
they usually list refusals?
You would
on
get a
that sheet?
refusal form, there's something, well...
I know they get a
You
refusal.
have, the CO is listed as redundancy, so he's denied, and it's...
Well, that's a denial.
Yes.
But was there a refusal form here? I didn't
Not
see
that I'm
one.
aware of, because it's an incomplete record, but I believe appellant counsel's right. The only thing that we're looking at is a check mark off of that. And that's why I say that's a closer call. I think that is a closer call.
But on that alone, because there was no inquiry as to why the refusal occurred, under our Barnes case, doesn't this...
Not on a motion to dismiss, I think, because of the peculiarity of this. There's no complete record here. I would say, the reason I say that is I could look at a harmless error, because he wants this guy, not because he was there, he's not one of the listed, he wants him to say the same thing 3 other inmates and a CO have already testified to.
Well,
I'm looking at
if
that.
you were to answer,
On the
answer the petition, and then it were to be addressed on the merits.
It would be addressed on the merits. My argument would be, he could have, this is harmless here, because he just wanted this guy to say the same thing 4 other witnesses had already said. I don't associate with these people. He didn't call, this wasn't someone who witnessed this. It wasn't one of the victims who said he's not the person who did this. This was simply, and that's why I think, again, that is a closer call here. And I see my time up.
Thank you, counsel.
Thank you.
Ms. Lee?
Requiring a prisoner to state reasons why he wants documents he has not yet seen, or witnesses he has had no opportunity to depose or even speak to because he's been in pre-hearing detention, would effectively insulate from judicial review the disciplinary hearings of the most vulnerable prisoners whose rights are at stake. All of the questions and the back and forth between Your Honors and Respondents' Counsel illustrate why the standard that the state is proposing is unworkable. There's not been a review on the merits of Mr. Henry's claim. What there's been instead is a kind of parsing of the record, who said what, when. Mr. Henry clearly stated in the hearing that he objected. He clearly asked for a very specific
Yeah, but
witness.
Mr. Mistracco points out that you've got this, he says, I want this thing to show that I was not there, right? And let's assume for a minute that we say that, all right, that's preserved, and that's subject to review. But if upon the appeal he says, I wanted to show that there are other witnesses I wanted to call, which is not something he said to the hearing officer down below, is that in your view preserved?
Your Honor, although the issues you raise may be relevant to the merits of the claim and whether or not it was a violation of Mr. Henry's constitutional rights to deny those documents.
I'm just speaking evidentiary in terms of preservation. I understand your point. I think if he was denied it, and that's enough to preserve it as far as I'm concerned. But when you then argue after that, in other words, it's preserved and you argue after that, and the reason that you want it is not the reason you told the hearing officer, but a new one that you've come up with, have you preserved it properly for review in a subsequent hearing?
Your Honor, if I'm understanding
Is that confusing?
If I'm understanding your question, then yes, it's not the issue is notice to the decision maker and an opportunity to address the issue in the moment. So as long as the decision maker has notice of what was requested, the unusual incident report, the logbook entry, the to from report, then the fact that Mr. Henry was not in the moment, did not articulate the same reasons that counsel, when we began representing him,
But I guess, I'm
forwarded.
sorry, Ms. Lee, not to interrupt you, but I guess to follow up on Judge Piggott's question, so if the inmate says, I want this incident report for X reason, and the hearing judge rules on that, and I think it's very hard then to say that's not preserved for review, the fact that you were denied this document. But on appeal, if the argument is, well, he should have gotten it for Y, is that argument preserved?
Your Honor, I think it would be a matter of whether the argument is sufficiently distinct enough to constitute a new legal issue that's being raised for the first time on appeal.
But what if it's a factual issue? What if it's a legal theory? That document was relevant because, he says, I want the document of the report. The hearing judge says, well, you're not even in it. And I think clearly that is enough to, you could argue that's enough to get that issue up. But then if you make a different argument as to why he should have gotten it, not because he wanted to show he wasn't in it, but for some other reason, doesn't that seem a little difficult for a hearing officer if you're arguing a new grounds for it on appeal?
If there's a distinctly new issue, a new legal question that's raised for the first time on appeal, then that would be a different situation than the one we're in, where Mr. Henry did not ask for the unusual incident report in order so that it could prove that he was not listed in it. He asked for the report. It turned out that the hearing officer shared some information about the report with Mr. Henry, but did not share the report itself. We still don't know. Counsel, we've never seen the unusual incident report. We don't know what it says in there. We don't know how it might have helped to show that Mr. Henry should not have been found
So
guilty.
he's requesting the report in the hopes that maybe something will be useful to him, but he can't say either way until he sees it. And so his reaction is to the hearing officer saying, well, this is the reason I'm not going to give it to you.
Exactly.
And that's what you want reviewed, it's just that denial of the report to the prisoner.
Yes, Your Honor.
Thank you, counsel.
Thank you.